In Robert Bork's America, there is no room at the inn for blacks and no place in the Constitution for women. And in our America, there should be no seat on the Supreme Court for Robert Bork. Mr. Bork has been equally extreme in his opposition to the right to privacy. In an article in 1971, he said, in effect, that a husband and wife have no greater right to privacy under the Constitution than a smokestack has to pollute the air. What I hear you're saying here now is that the test that was used about 90 years ago, and which was the basis for discrimination against women, is the standard that you would use. You may be able to elaborate on it, but that's at least what I'm hearing.
Well, I don't know that it was the basis for discrimination against women. I think that society saw all kinds of distinctions, legal distinctions between men and women as entirely reasonable and rational. This society no longer sees them that way, and that is fine.
Well, I just take 30 more seconds, Mr. Chairman. On numerous occasions over the last 16 years, Bork, you've suggested the Equal Protection Clause of the Constitution does not ban discrimination against women. Now you're suggesting the Supreme Court should apply the same lax standard to sex discrimination cases that applies in challenges to air pollution ordinances or economic regulations. You've also disapproved the Equal Rights Amendment. And finally, you also suggested in a 1985 opinion that the Civil Rights Act offers little, if any, protection against any one of the ugliest forms of gender discrimination, individual sexual harassment on the job. We've made great progress in the country in the last 20 years in giving women equal status under law, and I think the controversy has largely been settled. But you would have the Supreme Court evidently roll back the clock and reopen old wounds.
Senator, I think I must reply to that.